The question is that the bill be now read a second time. Mr. Christopher De Souza.
Sir, this bill furthers justice. How? By facilitating the realization of judgments into real, tangible benefits, even if these need to be realized overseas. This is especially important in a world where cross-border business transactions frequently occur and where assets and goods may be dispersed around the globe. Enforcement via a registration of judgment is a regime that allows for cost savings and greater certainty when an overseas judgment is being enforced. It is based on reciprocity, that is, that Singapore's judgments will be recognized and enforced in their jurisdiction, and that that jurisdiction's judgment will be recognized and enforced in Singapore, except for a few exceptions. This reciprocity is based on executive action, namely through the Minister making an order under Section 3 of the Act. At this stage, sir, allow me to disclose that I am practicing lawyer at the Singapore Bar. This bill streamlines and broadens the regime, furthering Singapore's position as a dispute resolution hub. Because our judgments will be more easily enforced overseas, parties will have greater reason to choose Singapore to resolve the dispute. As more cases in Singapore are heard, Singapore's jurisprudence will develop. With more established jurisprudence and greater familiarity with Singapore law, more contracting parties will choose Singapore law as the choice of law and Singapore as the place with exclusive jurisdiction. This bill streamlines the regime by removing the distinction between Commonwealth and non-Commonwealth countries. Although they operated in generally the same way, there were a few minor differences. For example, the tests for setting aside registration of a judgment on grounds of public policy are slightly different in Section 5A, Roman numeral 5, of the Reciprocal Enforcement of Foreign Judgment Act and Section 2F of the Reciprocal Enforcement of Commonwealth Judgment Act. This streamlined statutory regime supplements other processes by which foreign judgments are enforced in Singapore. The Choice of Court Act implements the Hague Choice of Court Convention, a multilateral treaty with 32 contracting parties currently. However, it does not include recognition and enforcement of interim measures. The statutory regime, as amended by this bill, will allow such reciprocal recognition if and when such bilateral agreements are entered into. Besides formalized statutory procedures, there are also non-binding memoranda between countries that help facilitate this process of recognition and enforcement. As of September 2018, the Supreme Court of Singapore had entered into memoranda of guidance as to the enforcement of money judgments with 5 courts in various jurisdictions. One such example is the Memorandum of Guidance between the Supreme People's Court of the People's Republic of China and the Supreme Court of Singapore on recognition and enforcement of money judgments in commercial cases, signed on 31st August 2018. Relevant to how the Reciprocal Enforcement of Foreign Judgment Act supplements and does not affect other existing regimes, would the Minister explain the rationale behind the retention of Section 7(1) of the Reciprocal Enforcement of Judgment Act, which says that, I quote, "No proceedings for the recovery of a sum payable under a foreign judgment, being a judgment to which this part applies, other than proceedings by way of registration of the judgment, shall be entertained by any court in Singapore?" Question mark. Does this mean that if a judgment could be enforced via the Choice of Court Act instead of the Reciprocal Enforcement of Foreign Judgment Act, that the Reciprocal Enforcement of Judgment Act must be resorted to and not the Choice of Court Act? That's a question. As this streamlined statutory regime supplements existing regimes, this bill also broadens the scope of the Act, making it more useful. Firstly, it broadens the kinds of judgment that can be registered under this Act, although retaining the limitations of certain kinds of judgments in Section 2(2). Clause 2 includes non-money judgments as a type of judgment. This is very helpful even for commercial matters. For instance, in cases involving intellectual property rights, the remedy may be to transfer property or to destroy infringing material. Coupled with the inclusion of interlocutory judgments as a type of judgment recognized by the Act in Clause 2, global Mareva injunctions can be registered and enforced without commencing a separate action. Because there may be differences in legal remedies available or some other reason where it may be just and convenient not to strictly enforce a non-money judgment, the new Section 4(3)(a)(b) gives the court discretion on how to enforce non-money judgments. Secondly, Clause 3(1) allows the Minister to recognize judgments coming from courts besides superior courts. The previous blanket ban against recognition of subordinate courts prevented Singapore's state court judgments from being registered overseas due to the need for reciprocity. Because of the increase in the jurisdictional limit of the state courts, cases that need to be enforced overseas have to be transferred to the High Court. This has disadvantages. The party who needs overseas enforcement may not get High Court costs from the other party, incurring greater unrecoverable costs. So, this change to make it possible for Singapore to enter into bilateral agreements that recognize judgments from our state courts directly is ideal. Even while this bill expands the possibilities for enforcing judgments and interim measures from other jurisdictions, this bill also puts in safeguards to prevent abuse. Firstly, the new Section 3(4) ensures that the judgment originates from the court recognized, preventing the requirement of reciprocity from being circumvented. Secondly, Clause 4 adds another ground for setting aside a registered judgment, that is, if the judgment was discharged. According to the explanatory statement, an example of this is in the event of a bankruptcy. Excuse me. This prevents the bankruptcy regime from being circumvented. Thirdly, the new Section 4(3)(b) allows Singapore courts to register a judgment for the amount of compensation, but not for punitive or exemplary damages. Unlike Section 16 of the Choice of Court Agreements Act, which provides the court the discretion to refuse to recognize or enforce the part of a judgment that exceeds compensation for the actual amount of loss or harm suffered, the position for such judgments are unclear under the Reciprocal Enforcement of Commonwealth Judgments Act and the Reciprocal Enforcement of Foreign Judgments Act. In this way, this bill makes the position under the statutory regime of registering reciprocal judgments certain and accommodates differences in legal remedies available in different jurisdictions. This is a major advantage. With more possibilities, albeit with inbuilt safeguards, there will be greater flexibility to negotiate bilateral agreements on the recognition and enforcement of court judgments. No changes seem to have been made to the list of countries under the Reciprocal Enforcement of Foreign Judgment Act and Reciprocal Enforcement of Commonwealth Judgment Act, at least since 1999. Hopefully, more bilateral agreements to this effect would be entered into following this bill. This would boost dispute resolution in Singapore, as the ability to enforce a judgment in multiple countries can be valuable for certain commercial disputes. Would the Minister share with us any plans to negotiate and conclude such bilateral agreements, especially for interim measures which the 2005 Hague Convention on Choice of Courts does not cover? In conclusion, sir, this bill opens a lot of opportunities for negotiating bilateral agreements such that Singapore's court judgments can be enforced overseas, furthering Singapore's position as a premier dispute resolution hub. And therefore, I support the bill.